All right, this is Clayton County Magistrate Court bond hearing calendar. Today's date is May the 1st, 2026. 2026. The first matter that we're going to do is the state of Georgia versus James Larry Johnson, and warrant numbers 2026 CW 50357, 2026 CW 50692, 2026 CW 51076, 2026 CW 51558, and 2026 CW 51559. All right, Mr. Rogers.
Thank you. And Judge, I guess my argument to start with would kind of apply to, I believe it's what they have listed as a smash and grab, because that's the one he does not currently have a bond set on. I would still ask the court, in considering the amount to keep in mind that the other bonds that he has that I show total up to, what was it, 55,000? So with that being said, speaking on the smash and grab, just from checking the jail screen, Mr. Johnson has been in for a while on that one since about February the 3rd, is I think what they show on there. The reason I mentioned that he's been in since February the 3rd on that particular charge is that by my math and the math online from the calculator I use, he is at 87 days in custody. At 90 days, he'll be entitled to a bond. With this being Friday, 3 days from now, I don't expect the state will have him indicted by then. I'm almost sure they won't have him indicted within 90 days. So I ask the court to kind of keep that posture in mind. And as far as Mr. Johnson's, part of the reason I mention that is because to the extent that we could just be back here next Friday about it and he would be entitled to a bond if they didn't get him indicted by Monday. The the factors about whether or not to set a bond at all, I think, have much less weight at this point. But to speak to him, I will, we have to acknowledge that Mr. Johnson does not have a great record. As the DA is already trying to inform the court earlier, he's got several previous convictions for burglary. I'm not going to try to hide the ball or anything of that nature. With that being said, I will point out that talking about burglaries, a lot of them, if I understand, I can't speak to the prior ones, but as far as the cases that we're here about today, to my knowledge, I think they all involve businesses as opposed to residences. And I know that's, I get that nobody wants any of their property broken into. But I do think the state itself recognizes that, they kind of have different effects on people. Mr. Johnson, as you can see, he's not in his youth anymore. By my math, he's 71 at this point. I will point out, I guess what I will say is that I do appreciate that Mr. Johnson is still an active member of society at his age. Obviously the alleged activity could be redirected. But with that being said, he's 71 years old. Jail is, it has detrimental effects on one's health. It's not a health camp. It's not a spa. And so for those reasons, Judge, I would also point out that, the point of bond is not to keep people in jail or to punish them for their record or anything like that. To the extent that the court, that the state doesn't want people to get out on bond, they have a mechanism for that. It's called indicting them within 90 days. They can always keep it a decision about the factors if they do that. If they don't do that, then they're in less of a position to argue against someone having a bond set. Additionally, I would also point out these are, economic crimes, so to speak, in the sense that, burglaries, especially I would presume of businesses, are done with an eye towards money. We're not talking about violent crimes or trying to, harm people or anything of that nature. So I would ask the court to keep that in mind also. Ultimately, in light of the bonds, the total on the other charges that he has, I would ask the court to set a bond on the smash and grab at 5,000. I think that would put him at a total of 60,000, if I'm not served.
How much are the bonds on his other accounts?
Give me 1 second.
Judge, would you like for me to tell you?
Yeah, you can tell me, whoever has it up.
I do. On the smash and grab, as counsel has stated, there isn't a bond set. On commercial burglary on 692, that one is $5,000. However, on commercial burglary on warrant 51076, that's 20,000. On warrant 51558, that's 20,000. And there's a criminal damage to property, and that one is 10,000.
Okay, so that's 40, 50. So it's 55 right now.
At this point, Your Honor. And then there's one that does not have a bond.
Okay. Okay. All right, Mr. Rogers, anything else on behalf of Mr. Johnson?
No, ma'am, Judge. Just like I said, ask you set that one at 5, put him at 60. He probably still can't make it, but he can at least aspire to it.
All right. All right, 88 Thomas.
And Judge, as I mentioned before, and that was just to be sure that we weren't going to be wasting the court's time this morning. Mr. Johnson's history has been fairly prolific, and it's also been fairly consistent, strangely enough. He started out with a theft by shoplifting and quickly devolved to burglary. At this point, beginning in 2010, he got a 4-count commercial burglary conviction. Then in 2010, again, he got a 2-count burglary. It doesn't say whether it's commercial, but it probably was. He got a subsequent conviction, two more in 2013, both of those for burglary. And his most recent conviction for burglary was in 2017. And then we are here today. And Your Honor, particularly that 2010 case with the 4 counts, that pattern resembles very similarly as far as the charges, what we have before the court today. Your Honor, these are all, let me see, 1, 2, 3 different businesses. Actually 4 different businesses, because one of these burglaries was in a plaza, and 4 different businesses. One business got hit twice. You know, if anybody could be said to be a danger to the community and a risk to reoffend, I would say it would be Mr. Johnson. And I understand counsel's argument about it's almost 90 days and the case has not been accused. So if the court is inclined to set a bond, I would ask the court set a bond consistent with warrants 2026 CW 51076 and warrants 2026 CW 51558. Those bonds are $20,000 each, which would be more consistent with the history that this gentleman has displayed. Ideally, Your Honor, this gentleman would have no bond. I do strongly believe that he is a risk to the community. And as far as being able to say whether you're less of a threat because you're burglarizing businesses, Your Honor, these days and times particularly, there's a cost to all of this, and that cost goes back into the community because these businesses they're not going to just shoulder the expense. They can't. So one of these burglaries, that was $1,600 worth of damages, not including the property that was actually taken. Another business, it was $208, and another one, it was $282. All that goes back onto the community and the people who try to patronize these businesses. The criminal damage, that door to be replaced that was busted in, that was in excess of $500 according to what the police were told. So I would ask the court to keep all of that in mind in its consideration of whether or not, if this gentleman should have a bond at this point, and if so, what that bond amount should be.
Is he going before the grand jury on Monday? Is he scheduled?
No, ma'am. We only have grand jury on Wednesday, and as far as I know, this one has not been scheduled. But
okay. In light of that information that he's knocking on his 90 days, the court will set a bond, and I'll set it at 20,000 and to stay away from that location in warrant number 2026 CW 50357.
Thank you, Judge.
All
And
right.
just to make sure, on the other warrant, the other cases that do have bonds, do they
Yes,
have
ma'am.
stay away from the various incident locations? There are at least
do.
4, maybe 5.
I'm looking at the bond artist. They do.
Okay, thank you, Judge.
All right, you're welcome. This matter is adjourned.